Mr Speaker.
I call Ria Bond.
Thank you, Mr Speaker. I'm pleased to rise on behalf of New Zealand First and take this call through the third reading for the Social Security Commencement of Benefits Amendment Bill. Mr Speaker, New Zealand First supports this bill, and I will endeavour to outline why. My colleague's contribution earlier in the first and second reading and throughout the committee stage of the simple bill is quite correct. This bill is merely seeking to amend a technical glitch and put in place a simple, fair and clear process to fix this glitch. New Zealand First had a supplementary order paper that basically asked the government to automatically include those beneficiaries who clearly can be easily identified by the records of WINS who will qualify for a payment under this bill we are debating about tonight. The purpose of this bill is relatively straightforward. It's set out in the General Policy Statement, outlined in the Departmental Disclosure Statement, and reads, "This bill amends the Social Security Act 1964 to correct with retrospective effect to 3rd June 1998, an error in the legislation that does not give effect to the policy intent that a benefit commences on the day after a stand-down period ends, as opposed to the day on which the stand-down period ends. It also provides that certain people are protected from the effect of retrospective amendment, including those who apply for a review of decision of the commencement date before, or in the case of a benefit that commenced on or after 20 May 2014, within 6 weeks after the bill comes into force." I've gone over this bill to get a clear understanding of the impact, the technical glitch this government finds itself dealing with tonight. I noted the Departmental Disclosure Statement asked valid key questions, especially under Part 4, 4.3. It asked, does the bill affect rights, freedoms, or impose obligations retrospectively? And clearly the answer is yes, it does. Provisions in the bill have retrospective effect, which could be seen as contentious, as generally legislation should operate prospectively and not retrospectively. However, in the case, this retrospective provisions can be justified to ensure the government policy intent is upheld. Practice and understanding that has been previously applied by the Ministry of Social Development is validated. Financial costs to the Crown that were not anticipated were avoided. The amendment to Section 80BA to correct the commencement date of a benefit so that a benefit commences on the day after a stand-down period ends will be retrospective to 3rd June 1998 in order to validate the Ministry of Social Development's previous practice and decisions. Mr. Speaker, it is the general understanding from New Zealanders that the government have a legal and moral duty to pay beneficiaries what they say they are entitled to. And once this assessment is processed at work and income, people go into a stand-down period, and therein lies the problem, the stand-down period itself. Which from listening to previous members speaking, seems to be the sinking ship. Clearly members do not agree with this mandatory stand-down period that in many cases can sadly force early stages of poverty. This is one of the consequences and barriers people in New Zealand face when they are standing in line to ask for assistance to keep a roof over their heads, meals on their tables, shoes on their feet. People like casual workers, teacher aides, seasonal workers, freezing workers, people who have been made redundant, or simply that their current job and their employer are just not a good fit. They go into WINS and apply for a benefit and get hit with that mandatory stand-down period and hope like hell that the last 50, 60 or even $100 will see them through the stand-down time. Mr. Speaker, I find it amazing that legislative muck-ups have occurred over many years under both National and Labor governments, such as this bill we are debating tonight under urgency. To recap for those viewers watching, this was an amendment to Section 80BA in the Social Security Amendment Act No. 2, 1998 that incorrectly changed the wording to the day the stand-down ends. The wording change was not picked up until it was identified in a Social Security Appeal Authority decision in May 2014, and thank goodness too. Now, 18 months later, here we are under urgency, debating this amendment and fixing a retrospective law to simply close this loophole up for good. The legislative error was unfortunate, and operational practice was changed from the 29th of September 2015 so that payments were technically in line with the wording of the law until legislative change is passed. This will now add clarity to work and income stand-down periods. I understand it's always been government policy that a benefit will commence the day after a stand-down period ends. For example, that means if you have a stand-down period of 5 days, then your benefit will kick in on the 6th day. This I know, and I'm not doubting it either, that this was the intention of how this legislation was to work, and of course the operational practices of work and income support should match up. The Social Security Commencement of Benefits Amendment Bill corrects the error with full retrospective effect to 3rd June 1998. This, New Zealand First believes, addresses the unintended consequences to beneficiaries and the cost to the taxpayers. It means by any beneficiary who has lodged a review of decision related to a benefit commencement on or after the 1998 amendment and before the passing of corrective legislation will still have their review process in the usual way. Mr. Chair, just quickly before I finish, I do empathise with beneficiaries because no matter which way this bill being debated under urgency tonight is covered, or how members in this House choose to debate this bill, comments on social media sites are already slamming them for expecting to benefit from the government's honest mistake. This has been an embarrassing oversight, and I'm sure a regrettable moment on both the National and Labor government's books. New Zealand First supports this bill.
Call John